In this video, I'm going to talk about the case of Walsh and Lonsdale. This is a rather old case on equitable lease. The facts are as follows. In May 1879, the defendant granted the plaintiff a lease for 7 years through a written tenancy agreement. I would like to highlight here that it was a written tenancy agreement. It was not a deed. This was problematic because under common law, a lease having a term for more than 3 years has to be executed by a deed. If it is not executed by a deed, it will not be enforceable at common law. So back to the facts. Under the agreement, 1 whole year's rent is made payable in advance on demand by the lessor. After signing the agreement, the plaintiff entered into possession and paid rent quarterly, not yearly and not in advance. Until March 1882, the defendant demanded payment, but the plaintiff defaulted, so the defendant distrained the plaintiff's goods. Distrain here means seize. Usually, the landlord has the right to distrain or seize the tenant's goods in the property when the tenant fails to pay rent. However, the tenant here considered that his landlord has illegally distrained his goods, so the tenant commenced action for damages for illegal distress, injunction, and specific performance against the landlord. The issue here is whether the distress was illegal, so could the defendant seize the plaintiff's goods? This turned on another question, that is, whether the plaintiff had been defaulted in paying rent, and this leads us to another question, that is, when was rent payable? The decision by the Court of Appeal is as follows. The court decided that the written agreement between the parties was not enforceable. As I've said, for a lease having a term for more than 3 years, a deed is needed to execute it. If the lease is not executed by a deed, it will not be enforceable at common law. But this is not the end of the story, because at common law we have something called implied periodic tenancy. To establish an implied periodic tenancy, we need to satisfy 2 requirements. The first requirement is that the tenant is allowed to possess the property by the landlord. This requirement is satisfied here because the tenant has indeed been allowed to possess the property by the landlord by virtue of the agreement. The second requirement is that the tenant pays rent on periodic basis, which is accepted by the landlord. This requirement is also fulfilled here because the tenant has been paying rent quarterly and the rent has been accepted by the landlord. So under common law, the parties had an implied periodic tenancy. However, the court eventually decided that the equitable principle of equity treats as done which ought to be done applies, so the parties in fact had an equitable lease. Let me explain the equitable principle. What is ought to be done here is that the 7-year lease should be granted by deed, but this was not done. The lease was not granted by a deed. However, equity will treat this to be done, so equity will treat the lease as if it is granted by a deed, so it will be enforceable in equity. In short, equity ignores non-compliances with formalities. To explain further why the court decided that equity prevails is because of the Judicature Acts. So a bit of British legal history. Long time ago there used to be 2 courts. There was the common law court and the equity court. Because of the Judicature Acts, these 2 courts combine into one. And the rule is that whenever there is a conflict between common law rule and equity rule, equity prevails. So take this case as an example. Under common law, the parties had an implied periodic tenancy, but under equity, they had an equitable lease. According to the rule, equity prevails. In conclusion, there was an equitable lease between the plaintiff and the defendant, so 1 whole year's rent was payable in advance on demand by the lessor, so the plaintiff was indeed in default of payment, so the defendant's distress was not illegal. So this is it about the case of Walsh and Lonsdale. At this point, you may wonder, so how is it related to Hong Kong landlord? The answer is as follows. According to Section 4, Subsection 1 of the Conveyancing and Property Ordinance, CPO, a legal estate in land may be created, extinguished, or disposed of only by deed. The meaning of legal estate can be found in Section 2, and it says that it includes a legal lease. But we have to bear in mind that there are exceptions to the deed requirement. One of them is under Section 4, Subsection 2 of CPO. Subsection D tells us that leases that take effect immediately for a term not exceeding 3 years at market rent can be created without a deed. So leases of this kind created without a deed will still be a legal estate. Another exception can be found under Section 6 of CPO, which concerns with creation of oral leases. So the example under Section 4, Subsection 2D is repeated in Section 6, Subsection 2. This means that this kind of leases can also be created orally and will still be considered as a legal estate. So this is about the deed requirement. What if we fail to comply with the deed requirement? Let's say we have a 7-year lease that is created orally, It is not enforceable by common law, but what about in equity? For equity to intervene, meaning that we want the equitable principle of equity treats as done which ought to be done to apply, as in the case of Walsh and Lonsdale, we need to satisfy two requirements. The first requirement is that the agreement has to be enforceable under CPO. It has to be in writing and signed by the party charged as stated in Section 3 subsection 1 of CPO, or if it is an oral agreement, there has to be part performance as stated under Section 3 subsection 2 of CPO. The second requirement is that no discretionary bar should apply. So, for example, we have the equity maxim of he who comes into equity must come with clean hands. So, given that these two requirements are satisfied, leases that do not comply with the deed requirement will be enforceable in equity. And in the UK, they have the Judicature Acts. We have a similar provision in Hong Kong as well, and that is Section 16 subsection 1 of the High Court Ordinance, which states that whenever there is a conflict between common law and equity, equity prevails. So finally, what if both requirements are not fulfilled or either of them is not fulfilled? What can we do? We may consider implied periodic tenancy. So we have to look at the evidence to determine the duration of the tenancy. For example, if rent is paid quarterly, then we may have a quarterly tenancy. If rent is paid monthly, then we may have a monthly tenancy. As you can see, one difference between implied periodic tenancy and an equitable lease lies in duration. For example, if a tenant and a landlord initially decided that they would have a 7-year lease, but then it turned out that the lease was not enforceable in equity and in common law, then it may turn out that they have a quarterly tenancy or a monthly tenancy. This may be different from the initial intention. So it is possible that either of the parties will want to argue for equitable lease instead of implied periodic tenancy in court. And other difference between the two types of tenancy is that for implied periodic tenancy, the tenancy will come to an end automatically upon expiry of the term unless the parties have agreed otherwise. So this is all we have to know about Walsh and Lonsdale. Thanks for watching.